In Georgia, you need one of two requirements to modify child support. There has to be a passage of time of at least 2 years, or there has to be a material change in one of the parties' income, which means that one party either earns more or less than, let's say, about 25% than they originally earned when the child support amount was calculated. So once a court has entered a child support order, you cannot modify child support whenever you want. So there has to be either a material change in income of one of the parties, or there has to be a time passed of at least 2 years. The process to modify your child support amount will look fairly similar to the original case that established a child support case. So you have to start your case with your plead-ins. You may or may not go through mediation. And then you may either settle at the new child support amount or you may go before a judge. But either way, you have to show that there has been a material change in income of one of the parties that changes the child support amount. Or if 2 years have passed, you may petition the court because usually after 2 years, the child support will change because the one or more party will have changed income. One of the factors that anyone should consider before they file a child support modification is whether it's worth it. There has to be some kind of cost-benefit analysis in determining whether the cost of hiring an attorney is going to offset any potential child support increase that you may receive. We turn cases away where we do not believe that the person would benefit from a child support modification. But the best way to know that is to book a consultation. There are several legal consequences to failure to pay. Those may include, 1, having your license suspended, your tax returns may be garnished or taken away. Finally, you can actually go to jail for failure to pay child support. So if you find yourself behind on your child support obligations, speak to an attorney at once to help you create a plan to get caught up. If you have a court order and are to receive child support for your children and the other parent is not paying, you have options. You don't have to sit and let the other person not pay. You can, of course, always try to resolve the issue amicably with the person and ask them to resume their payments and catch up on other missed payments. But if they refuse to do that, you can always go to court and file a contempt action. A contempt action is an action where you tell the judge that there is a court order that an individual is violating. And if the judge finds that the order orders a specific action that the person is not taking, the judge can enforce a series of punishments, including jail time. If you have any questions about child support, whether how is it calculated, how do you enforce child support payments, book a consultation with us. We'll be happy to review the facts of your case with you.